There were plenty of infringement on people's rights during the COVID-19 scamdemic, and censorship was rampant. Not only did we have members of our own government colluding to censor information they didn't like, but we've had professional associations joining in. Worst of all, the so-called medical professionals seem to be at the forefront, violating the central tenet of the Hippocratic Oath. First, do no harm. So we'll discuss this next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach, rise, and generation be free. I'm glad you could join me today. This censorship situation with these medical professionals, to me, very interesting. I have a lot I want to get into. Now, if you'd like to join me here and maybe take your hand at maybe writing some articles or doing some of this, well, please contact me at the website constitutionstudy.com. My previous intern has moved on to other things, and I wish her well, and I'm looking to take somebody else on, another volunteer intern that may be generating content and working with me, collaborating on content for the Constitution Study. I'll talk more about the website and some other things that are going on at the end of the episode, but for now, let's get into this medical censorship. People talk about how people are losing faith in our institutions, and it doesn't help when those institutions violate our trust. In the case, Association of American Physicians and Surgeons Educational Foundation, or AAPS, versus American Board of International Medicine, American Board of Obstetrics and Gynecology, American Board of Family Medicine, and Alejandro Mayorkas, Secretary of the U.S. Department of Homeland Security, the question is, did these medical associations collude with the federal government to censor medical information critical of the government's position? The Association of American Physicians and Surgeons Educational Foundation, or AAPS, alleges that the National Medical Specialty Certifiers, American Board of Internal Medicine, American Board of Obstetrics and Gynecology, American Board of Family Medicine, together known as the Board Defendants, and Alejandro Mayorkas, as Secretary of the U.S. Department of Homeland Security, known as the Department, coordinated to censor and chill the speech of physicians, including some who associated with AAPS, who spoke critically of positions taken by Dr. Anthony Fauci, lockdowns, mask mandates, COVID vaccinations, and abortion. This was and continues to be done by labeling dissenting views as misinformation, disinformation, and malinformation. And the board defendants have expressly threatened to strip certification from otherwise qualified physicians who express such views. Now, according to AAPS, appellees' efforts to censor and punish physicians on issues of public concern harmed and continue to harm AAPS. The accusation is that these medical boards attempted to censor medical information by falsely labeling it misinformation, disinformation, and malinformation. The whole idea of the scientific process is to search for truth. This works by questioning everything, then testing to see if it is true. The act of labeling something wrong rather than providing evidence is the antithesis of science. The question in this case isn't just, did these organizations collude with each other, but did they collude with the government of the United States to censor information? Because of these claims of collusion, AAPS sued the Board of Defendants and Alejandro Mayorkas, Secretary of the Department of Homeland Security. AAPS brought a host of claims against the board defendants and department, including First Amendment and antitrust claims. The district court dismissed all of AAPS's claims with prejudice, reasoning that it lacked standing to assert its claims against the board defendants and that the department mooted claims against it by dissolving the Disinformation Governance Board, which AAPS alleged was responsible for censorship. The First Amendment claims can only have limited jurisdiction. As I've said, I don't know how many times, the First Amendment limits laws Congress can pass. The First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. So if the Department of Homeland Security abridges someone's freedom of speech as an agency created by Congress, well, that would violate the First Amendment. But private organizations cannot. The district court dismissed all of the claims with prejudice, meaning they could not appeal to the same court. The district court claimed that the AAPS did not have standing to sue. The court also decided that the issue against the Department of Homeland Security was mooted when the Disinformation Governance Board was dissolved. Now, that may be what the district court decided, but the Fifth Circuit Court of Appeals disagreed. The district court incorrectly dismissed AAPS's First Amendment claims on standing grounds. AAPS provided sufficient allegations to support standing. See, the circuit court says the district court was wrong. Let the court list the ways. AAPS asserts an injury in fact through the board defendant's infringement on its right to hear willing speakers, and it is premature to require AAPS to name specific willing speakers at the pleading stage. AAPS claimed that the board's decision threatened the licenses of people willing to speak at their events. Later in the decision we find, AAPS contends the board defendant's threats to strip certification and properly chilled speech without the political accountability of official state medical boards. And through this chilling of speech, the board defendants interfered with the market for medical conferences and posting of such conferences to the internet. Some examples of chilling by the board defendants includes ABOG sending letters to all certified physicians threatening to strip them of their invaluable certification for making statements concerning abortion and contraception, or for warning pregnant women that the COVID vaccine could have negative side effects. ABIM and ABFM sent similarly threatening letters on May 26, 2022 to certified physicians for making statements disagreeing with positions taken by Dr. Fauci and the Biden administration in handling the COVID pandemic. Indeed, AAPS notes that one of its conference speakers had his certification stripped by ABFM pending appeal. AAPS provided examples of the board defendants threatening their members' certifications for expressing ideas, but could the AAPS link those threatening letters to abridgment of speech? AAPS can trace its injuries back to the board defendants' actions because physicians would likely react predictably when confronted with a threat of decertification. They would choose self-censorship over professional self-immolation. If these boards threaten the certification and, by extension, the careers of doctors who express ideas not promoted by the government actors, that would seem to be an injury in fact, wouldn't it? AAPS injuries are redressable, as ruling in its favor would allow for physicians to attend and speak at AAPS events and thus allow AAPS to exercise its right to hear without fear of decertification. Lastly, the injuries suffered by AAPS could be redressed. After all, without the threats of their certifications, physicians would be more likely to speak at AAPS events. Now, what about the complaint against the Department of Homeland Security? However, it was right to dismiss AAPS's claim against the department because its complaint, as currently written, lacks sufficient allegations to overcome the government's good faith carve-out to the mootness doctrines of voluntary secession exception. But it mistakenly dismissed the claim with prejudice, even though jurisdictional dismissal, such as those made on standing and mootness grounds, are typically done without prejudice. So we modify this dismissal to be without prejudice and affirm as modified. The circuit court claims that the AAPS claim against DHS couldn't overcome what's called the government's good faith carve-out to the mootness exception. Now, the good faith carve-out, or the good faith exception, means if the government acted in good faith, courts tend to side with them. But when the government established the Disinformation Governance Board, were they acting in good faith? After all, it was a blatant violation of the First Amendment and was shut down after just 4 months. There is a more serious question that we should answer, and that is the power of private associations when they collude with the government. The board defendants have medical certification monopolies over their respective specialties. These certifications are primarily based on multiple choice medical examinations. Board certifications constitute a de facto essential credential for physicians to practice and participate in most hospitals and insurance networks. Meaning that while physicians are not required to have board certification to practice, state medical boards control licensure. Lacking such certification significantly hamstrings their ability to do so. Stripping a physician of his certification is tantamount to revoking his license to practice medicine, given how few hospitals and networks permit uncertified yet licensed physicians to join. AAPS says that this monopoly status affords the board defendants an ability to exercise great power over physician speech. Here I find myself with an interesting conundrum. On the one hand, I see the importance of accrediting organizations. After all, who is better to determine the qualifications for a doctor? The government or other doctors? Now, while state medical boards may issue licenses, most hospitals and insurance networks require their physicians to have these certifications. However, when these organizations become politicized, they do great harm to the medical profession. What could be worse than a politicized certification board? A certification board colluding with government actors. AAPS alleges that the board defendants colluded with the Biden administration, imposing such censorship to promote the administration's political preference in exchange for government endorsements of their certifications. The letters sent by the board defendants were, according to AAPS, sent nearly simultaneously and with similar terminology as part of a broader campaign by the Biden administration to advance its particular partisan agenda concerning COVID-19 and abortion. AAPS contends that this collusion, resulting in attendant censorship and chilling of speech, infringed on its First Amendment protections and interfered with its ability to participate in the marketplace. AAPS claims that these board defendants were working with the Biden administration to advance the government's political agenda. This is very interesting. But before digging deeper, let's see some of the evidence AAPS brought to the case. Around the same time that the board defendants sent their letters, the department created the now defunct DGB. The department issued a press release in May 2022 directing the Homeland Security Advisory Council, HSAC, to make recommendations for how the department can most effectively and appropriately address disinformation that poses a threat to the homeland, while protecting free speech and other fundamental rights. AAPS points out that the Department of Homeland Security created the Disinformation Governance Board, the DGB, around the same time that the board defendants sent their letters. Since the DGB was closed only a few months later, the district court claimed that the complaint against the DOJ was moot. But was the complaint against the DOJ or the DGB? And what would a First Amendment case be without a misrepresentation of what the amendment actually says? The First Amendment protects the right to hear as well as the right to speak, so that which silences a willing speaker also works a constitutional injury against the hearer. This is on the case of Besdarians versus City of Galveston. Now, except the First Amendment does not protect a person's right to hear, but a person's right to speak, publish, and to peaceably assemble. If you had the right to hear, then you could not be prevented from attending a concert simply because you didn't purchase a ticket. The venue would be denying your right to hear. Now, Judge James C. Hole filed a dissent, but I don't think that's the proper term for it. Doctors deserve our tremendous respect. We trust them to provide us with the best available medical advice and treatment. But they're not perfect. Doctors are susceptible to peer pressure, careerism, ambition, and fear of cancel culture, just like the rest of us. At various times throughout history, medical care has suffered, and patients have been harmed, even killed, because doctors succumb to social pressure and desire for approval and advancement. We may look back in disbelief at doctors who are ridiculed and ostracized proponents of hand washing and sterilizing surgical instruments to prevent disease and infection. But we would do well to learn from our past. Yes, we should absolutely follow the science, but that doesn't mean we should always follow scientists, because scientists don't always follow the science. So far, a very good argument against medical censorship, but the dissent goes on. In this case, a medical association contends that certain medical boards and federal officials have conspired and continue to conspire to censor and even destroy the careers of any physician who dares to express the quote-unquote wrong viewpoints on a wide range of medical topics, including, but not limited to, Dr. Anthony Fauci, COVID-19 lockdown policies, mask mandates, vaccines, and abortion. These are alarming allegations. After all, these issues are far from scientifically settled as defendants claim. They should remain the subject of open and rigorous discussion, not self-censorship and cancellation. I agree with the majority that the district court erred. I would simply go farther and accordingly dissent in part. I would remand this case for further proceeding on all of the association's claims, including those against the government officials sued here, which the majority dismisses as moot. So this dissent sounds more like a concurrence, since the judge actually agrees with the majority opinion, with the exception that he would remand the case on all of AAPS's claims, not just some. This is the decision of the Fifth Circuit, and it may be appealed to the Supreme Court. From my point of view, there are things we can learn and questions we should ask about our medical institutions. As James Madison noted for the National Gazette on March 27, 1792, he has an equal property in the free use of his faculties and free choice of the objects on which to employ them. That means that physicians have a property in their certifications that they've earned. When those certifications, and by extension their ability to practice their profession, are threatened for any reason other than their medical actions, those doctors have been deprived both of their liberty and property without due process of law, which violates the Fifth Amendment, which states, "No person shall be deprived of life, liberty, or property without due process of law." When private organizations punish doctors for what they say, it is not a violation of the First Amendment. It is a violation of the Due Process Clause. And if the AAPS is correct and these medical associations colluded with the Department of Justice, then the DOJ has violated the First Amendment's free speech and free press clauses. This is the conundrum. Do we want government bureaucrats to regulate the qualifications of doctors, or do we want other doctors to do so? As Judge Ho said, doctors are just as susceptible to peer pressure and careerism as anyone. So where does that leave us? I think the best solution is to treat medical certifications as the property they were designed to be. If a doctor can pass the exam, they not only hold the certification, but it is their property. Like any other property, it should only be taken away when it's used unjustly. In other words, not because of what a physician says or writes, but for violations of the standards in the exams that led to the certification. I think both the association and members of its various boards should be held liable for the unjust abuses of their certification powers. After all, if you cannot sue the entity that has taken your property unjustly, how can you seek a redress of your grievance? I also think since the power to regulate medical care is not delegated to the United States, any department or agency thereof should be prohibited from influencing their standards by criminal statute. It is not enough to simply say a department or agency cannot influence board standards, but there must be punishment for those who do. I cannot think of another way to constitutionally protect both the medical profession and the professionals that practice it. If we want to avoid future politicization of medical boards, then they must be held accountable for their actions. If the board can justify their actions to rescind someone's certification based on their actions, they are fulfilling their role in protecting us from unqualified doctors. If they cannot defend their actions, they are not qualified to question the fitness of doctors to practice. So what do you think? Should medical boards have the ability to ruin a doctor's career based on what he or she says or writes? Is it even right for these medical boards to have monopolies over certification? Is it even right for hospitals and insurance networks to require a certification from a politicized entity like the current medical boards? And are all medical boards politicized? There's a lot of questions we can ask here. What I want you to look at here is the question that the Fifth Circuit looked at. First, did the board defendants infringe on the rights of AAPS and its members by threatening the certification of anyone who didn't speak the right words, who came up with ideas that were not politically correct? And did the Department of Justice violate the First Amendment by colluding with these boards in what was and was not allowed to be said without threatening certification. Again, this was heard at the Fifth Circuit. It's been remanded to be heard again. It very well may come back to the Fifth Circuit and may even make its way all the way up to the Supreme Court. But I want you to think about it this way. Do you want your doctor being trained based on politics or in medicine? Do you want your doctor certified to treat you because of the politics he espouses or the medical training he has received and shown a capability of performing? For me, the answer is the latter. I don't care the doctor's politics. If I'm having a heart attack, I want a cardiologist that knows what they're doing. They've passed their boards and they're qualified. I don't care if he supported Joe Biden or Donald Trump. I don't care. When my heart's in trouble, I want a cardiologist. When I'm looking for political advice, that's a different question. And as long as we have these politicized medical boards, we're going to continue to watch medical care suffer for politics. I don't know about you, but that's not what I'm looking for. Now, if you're aware of any other examples of politics meddling in not just our healthcare, but our lives, well, please let me know. Go to constitutionstudy.com/questions and ask a question about it. I'll see what I can do. If you'd like me to write about it, let me know. By the way, if you'd like to write about it, if you'd like to try being a voluntary intern here, a volunteer intern, well, again, go to constitutionstudy.com/questions. Say, hey, I have this idea. I'd like to write an article. And we'll see what we can do. The point is, I want to be able to educate as many people as I can. And that means reaching out and helping others to learn how to educate as well. You can find all this at the website, constitutionstudy.com. And you can find other content that I'm creating. By the way, you can also join me at the radio program, AmericaOutloud.news. You can find the Constitution Study there. I also found this great little this course that you can take. It's called The Miracle of America. I thought it was pretty neat. So neat that I made a deal with the publishers to get you a lesson absolutely free. Go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. And you'll be taken to a custom landing page just for Constitution Study listeners. You can read up on the course, but more importantly, you can enroll for a free lesson on God's natural law. If nothing else, take the free lesson. It'll be worth it. If you decide to take the whole course, it's just $17.76. Again, the website's constitutionstudy.com/1776 study guide to get access to the free lesson. Now, if you have any ideas or content you'd like me to look at, well, again, contact me through the website, constitutionstudy.com, or just send an email to support@constitutionstudy.com, and we'll see what we can come up with. I don't guarantee to cover everything, but I'll at least look it over. I hope you've enjoyed this. I hope you've told your friends, and maybe bring them along next time for the Constitution Study.
Love the neighbors and have a few good friends.